Hello, my name is Josh Blackman, and it's my honor to welcome you to the 2022 Harlan Institute Ashbrook Virtual Supreme Court competition. We are pleased to present the final four round. This is the second match in the case of Students for Fair Admissions versus the University of North Carolina. Representing petitioners will be Alex Chen and Forum Shah from Westchester, Pennsylvania. And for the respondents, Katie Gutowski and Quinn Speck from the Joel Barlow High School in Connecticut. Judge Murphy will be presiding whenever you're ready.
Thank you. And it's a pleasure to be here today with Judge Batchelder and Judge Lee. With that, we'll call our first and only case, Students for Fair Admissions versus the University of North Carolina. We'll start with the petitioners, and you can begin when you are ready.
Mr. Chief Justice, and may it please the court. My name is Forum Shah.
My name is Alex Chen.
And we represent the petitioners and Students for Fair Admissions versus the University of North Carolina. To briefly restate key facts, in 2014, petitioners sued respondents, the University of North Carolina, for their use of race-conscious admissions policies, which petitioners believe to be in violation of the Equal Protection Clause of the 14th Amendment. As it stands, underrepresented minorities at UNC may receive plus factors to their application on account of their race. These pluses improve a student's chances of being granted admission into UNC. Evidence presented at trial in the district court demonstrates that race is considered at every stage, from recruitment to evaluation. Academic achievements such as SAT scores and personal qualities are qualified based on a student's race. UNC rejected race-neutral alternatives in the district court, such as the modified Hawksby simulation and various percentage plans. This court granted certiorari in January of last year.
Your Honor, UNC's use of race-conscious admissions practices is an unequivocal violation of the Equal Protection Clause and of Title VI. This court should rule in favor of petitioners and therefore overrule Grutter v. Bollinger for three primary reasons. First, Grutter, the precedent that UNC's practices rely on, is inconsistent with this court's decision in Brown v. Board. Second, based on principles established in Ramos v. Louisiana, Grutter bears the hallmarks of a case that can and should be overturned. And lastly, under application of strict scrutiny, UNC's current practices do not even survive to begin with. In Brown, this court rejected the right to use race as a factor in affording educational opportunities. It enshrined access to education on equal terms, and it concluded that public education must be considered in the light of its full development and present place in American life. In the present, Grutter permits race solely as a plus factor for applicants. This is inherently inconsistent with how UNC's practices operate.
What do you make of the fact that in Brown, the court was trying to bring races together, and that is what North Carolina is also trying to do here, whereas your position would make it harder to have a diverse student body, and in that sense is inconsistent with the purposes of Brown?
Your Honor, the intention of Brown was to bring races together on equal footing as held in that decision. In this case, what we're seeing the University of North Carolina do is bring students together by creating unequal footings for others, and we find that to be inconsistent with the intention of Brown. Students who have seemingly identical academic indexes and rigors have their achievements diluted and broadly qualified based on them not being an underrepresented minority. For example, white and Asian applicants consistently receive lower personal quality ratings despite race having no such effect. Your Honor, to put it simply, if a student has to excel deciles above another in order to receive an equal admissions opportunity on equal terms as enshrined by Brown, his or her race is a hindrance and thus an inherent negative. The practical effect is this: the use of race at UNC creates inherently unequal terms that deprive students of equal educational opportunities. We open to the questions of the court.
What do you, so you started with Brown. I'm curious why you did that. Do you think the original understanding of the 14th Amendment allowed for race-conscious decision-making, especially since the founders of the 14th Amendment or the enactors of the 14th Amendment were the same folks who passed the Freedmen Bureau laws that gave benefits to the newly freed slaves? Those were benefits targeted at particular individuals. It was largely based on, in some respects, based on race, because race was tied to the prior slavery. So do you concede that the original meaning is inconsistent with your approach and you're relying on Brown, or do you think it is consistent?
Your Honor, for example, the Freedmen's Bureau Act and other race-conscious legislation of the Reconstruction era, all of those measures were focused with the purpose of remediation in mind, which is completely different to the interest in today's case. In the Reconstruction era, the circumstances were very different. The Freedmen's Bureau Act, for example, provided aid as if one might give a refugee. Therefore, we do not believe that what the framers' use of race-conscious policies is inconsistent with our argument. Instead, what we take from Brown is that in its holding, Brown said that public education must be viewed in light of its full development. And when we look at this development, it's very clear that a plus for one race has an inherent, strongly felt negative for another race. And therefore, we believe that this race-conscious measure is unconstitutional.
So is your position that the government could use race in certain contexts, but not here because diversity isn't a compelling interest?
Yes, Your Honor. We're not saying that race can't be used at all. This court has held several times that remediation, for example, is an acceptable use of race. However, the use of the compelling interest of student body diversity is completely unconstitutional. This court in McLaughlin v. Florida held that it must be a necessary purpose for achieving a certain governmental goal. So much so that in Palmer v. Sadati, it found that the use of race for parental custody is not a compelling interest. That in Johnson v. California, reduction of gang violence is not a compelling interest. Yet at the same time, we understand that cross-racial understanding is a compelling interest. We find that to be wholly contradictory and undermining of this court's understanding of what a compelling interest should be.
Can you address the reliance interest in overturning Grutter? And in many ways, actually, you're asking for more than just overturning Grutter. We're actually going back to Bakke back in 1978 or whenever it was decided. So for the past 50 years, universities have considered race to create a diverse student body. And that student body then funnels into corporate America, the officer ranks in the military, academia, and a lot of other jobs. So this is how society and the universities have structured college admissions to ensure diverse university, diverse workforce. Aren't you now saying that we have to start with a clean slate and completely upset the cart that we've become accustomed to in the half century?
Your Honor, if I may respond with 2 points. First, it would not be profoundly disruptive to overrule Grutter because there are race-neutral alternatives available. And as this court has said in US v. Paradise, when considering whether a case should be overturned and whether it satisfied strict scrutiny, we look towards the feasibility of available race-neutral alternatives. Overturning Grutter would not be profoundly disruptive because race-neutral alternatives such as top X percentage plans, modified Hawksby simulations exist and work. For my second point, when this court first decided Grutter, it was understood to be a temporary provision. Whether we take Sandra Day O'Connor's 25-year limit literary or, as a ballpark, it is still understood by the court that it was a temporary provision. So reliant interests were not meant to be built on a measure as temporary as race in college admissions. It was understood by this court that it was not a permanent measure.
So you mentioned alternatives there. What do you make of the statistics and the brief of your friends on the other side that suggest those states that have transitioned to race-neutral policies like California have struggled to have a critical mass of different races as a result of those bans? How should that play into whether we should overrule Grutter?
Your Honor, we find that systems like the University of Michigan or like the University of California have failed to change the emphasis from race to other factors such as socioeconomic status, which will also achieve that level of diversity. Studies show that the introduction of AAA policies would increase the UC system's diversity. In the University of Michigan system, 10% of their class comes from the top 1% of household incomes. Instead of focusing on this emphasis of race, there are other ways that these systems can be achieving this and that they have not. And therefore, we still believe that these administrative challenges that they're facing can be dealt with and that they're just refusing essentially to implement them.
Well, do you want to sum up? You've got about 30 seconds left and we'll hear from the other side.
Yes, Your Honor.
Your Honor, essentially, there are three prongs to our argument. One, Grutter, the precedent that UNC's practices rely on, is again inconsistent with Brown v. Board. Not only that, but the principles of stare decisis that this court has recognized can and should be overturned based on this court's understanding of Ramos v. Louisiana. And lastly, under the application of strict scrutiny, UNC's current practices do not even survive to begin with, whether by Grutter's two-prong hallmarks or by the standard of strict scrutiny review. Thank you.
Okay, thank you, counsel. We'll now hear from the respondents. Okay, you can begin when you're ready.
Right. Mr. Chief Justice, and may it please the court. I'm Quinn Speck.
And I'm Katie Katowski, and together we represent the respondents in the case of Students for Fair Admissions v. the University of North Carolina.
Would the court like a brief summary of the facts?
No, thanks.
Today, we argue that this court should affirm because the University of North Carolina's use of race-conscious policies in its admissions process is constitutional under the 14th Amendment's Equal Protection Clause by both the text and history of the 14th Amendment, as well as the precedents of Bakke in 1978, Grutter in 2003, and Fisher II in 2016. Contrary to what petitioner wrote in the summary of their argument on page 14 of their brief, neither in Brown v. Board's holding nor in its opinion did the court explicitly use the language that it rejected the use of race as a factor in affording educational opportunities.
The court correctly held in Grutter that the 14th Amendment's Equal Protection Clause does not prevent the limited consideration of race by admissions offices as part of a holistic process, as long as that consideration is narrowly tailored to the compelling interests of student body diversity for its demonstrable educational, economic, criminal justice, and national security benefits. The University of North Carolina's use of affirmative action is narrowly tailored to that compelling interest, and therefore should be upheld under strict scrutiny. At this time, we open ourselves to questions from the court.
Well, I'll start. You suggested that Brown maybe was conducive to an interpretation that supports you, but what about just the plain text of the 14th Amendment? The text says, no state shall deny to any person within its jurisdiction the equal protection of the laws. It's hard for me to deduce how this would allow discrimination for some races, but not for others. It strikes me as a categorical ban on the use of race when it says equal protection of the laws and every person. So I wonder if you could respond just to this plain textual.
Well, as it relates to the original meaning of the Equal Protection Clause of the 14th Amendment, according to congressional records from 1866, the framers understood that race-conscious policies were needed to ensure, quote, the gulf which separates servitude from freedom is bridged over. And as we outline on page 12 of our brief, in fact, the framers of the 14th Amendment rejected numerous drafts of proposed constitutional language that would have prohibited race-conscious measures designed to help African Americans achieve equal citizenship. They believed legislation passed to ensure equal opportunity for African Americans was consistent with and not contrary to the newly passed 14th Amendment. And by approving race-conscious policies in order to promote racial equality, the framers recognized that the true goal of the 14th Amendment was to, quote, break down discrimination between whites and blacks, not to ensure color blindness, which is again from congressional records from 1866. So
what do you make of the fact? So the Equal Protection Clause is a ban on state action, so actions by North Carolina and the other states. It's not a ban on federal action. So why would the laws passed by the federal Congress influence what we think the 14th Amendment should mean, since the 14th Amendment wasn't even supposed to apply to the federal Congress?
Well, really, Your Honor, if you're looking for public schools and policies from public schools and not from the federal government, by 1869, almost 3,000 schools with over 150,000 pupils reported to the Bureau, the Freedmen's Bureau, that is, which helped set the foundation for Southern public education of people of all races. And it might have been funded by the federal government, but those were state schools. And so it's really grounded from the beginning in the 14th Amendment.
I want to
And,
go back to
additionally-
what you had said earlier, suggesting that during the Reconstruction era, the framers of the 14th Amendment, were the Congress then were passing race-conscious laws. I mean, to use a more recent historical example, the United States government paid reparations to Japanese Americans who were interned in camps during World War II. In that case, was that a race-conscious remedy, or was it just compensating people who were specifically harmed by the government's action?
So we do believe that it would fall into a similar category as the Freedmen's Bureau Act, where I believe, as Justice Murphy acknowledged, essentially, although it was technically the category of former slaves, it still carried over to the category of African Americans. And we believe that, this interest of remediation that our opponents have talked about is tied ultimately to diversity.
I guess, I'm not convinced that it's the Freedmen's Bureau and other legislations were race conscious remedies. And maybe it just turned out because African Americans were enslaved, those laws benefited from them because we wanted to help out former slaves. But did it sanction specifically race conscious laws?
Well, Your Honor, we would point to the fact that Reconstruction policies didn't just apply to African Americans that were freed from slavery. If we look to the University of Michigan at the time, Michigan didn't have slavery before Reconstruction, but it still enacted race-conscious policies during Reconstruction, which was in general make up for nationwide discrimination. So it wasn't just in strictly Southern states or for those impacted by slavery directly even then. So we would say, again, going back to the language of the 14th Amendment, that no state shall deny to any person within its jurisdiction the equal protection of the laws. We believe that then this extends, and history has applied this to races outside of just African Americans, as well as far beyond those just freed from slavery.
And furthermore,
Well, doesn't this could suggest that you have an argument that remedying past discrimination is a compelling state interest. But the argument here, as I understand it, is that diversity alone is the compelling state interest. Isn't that a pretty big leap from a narrow remedy for past discrimination to just allowing for the diversity in college admissions writ large?
So, Your Honor, we believe that to some extent, the lack of diversity on campus today is a legacy of the failure of remediation. The end of the Reconstruction era as a consequence of the Hayes-Tilden election made the imposition of Jim Crow possible. And today's racial disparities, while not comparable in scale, are traceable to that history, which is what created the need for action of these schools to ensure the compelling interests of student body diversity. It does not naturally exist with only race-neutral policies. And furthermore,
we've never held that remedying societal discrimination is compelling interest. You can remedy specific cases of discrimination, but not general societal discrimination.
Well, Your Honor, that's not the interest that we have here in this case. We bring up the history of Reconstruction to show that race-conscious policies have been constitutional from the time of the 14th Amendment being written, but the interest has evolved to diversity, and this court has held for half a century since Bakke in 1978 that the interest of diversity is compelling. Between the cases of Fisher to Bakke and Grutter, this court has said that being exposed to diverse ideas leads to enhanced classroom dialogue, lessening of racial isolation and stereotypes, and increased cross-racial understanding, as we discuss on page 46 of our brief. And we would also highlight that these benefits apply to all students and society at large, regardless of their race or background, and that there are demonstrable educational, economic, criminal justice, and national security benefits of this student body diversity. And even more so, to respond to the point that petitioner makes, where they say that this isn't a compelling interest. As discussed in the opinion in Grutter by Justice O'Connor, The reason why the interest of diversity satisfies the standard of a compelling interest is because it prepares students for a diverse workforce and improves classroom discussions. Justice Thomas, even in his dissent in Grutter, also used the examples of national security, safety from violence, and the functioning of government as compelling interests. And we believe that we demonstrate those as well. Student body diversity is necessary to national security. If we look to the Vietnam War, as we discuss on pages 53 and 54 of our brief, racial conflicts caused by the lack of diversity in military leadership led to injuries, death, and the prosecution of only Black sailors. And the Department of Defense has since recognized that diversity is integral to overall readiness and mission accomplishment.
And
Well,
only-
even if that's true, what you have to show both compelling interest and narrow tailoring. Why wouldn't it suffice to use race neutral means to satisfy the strict diversity criterion? I would think somebody who's grown up in a poor home, whether white, Black, Asian, or any other race, might have a different perspective than somebody who's grown up in a well-off home. So why isn't the use of maybe a socioeconomic criterion as a way to achieve diversity sufficient? Don't you have a duty to prove that would somehow be inadequate to serve your diversity purpose?
So yes, Your Honor, and as I believe you mentioned when you were questioning the petitioners, leadership of both California and Michigan's university systems, public university systems, have filed amicus briefs in favor of the respondents, which indicate that they themselves feel that their race neutral programs have not been successful in obtaining the same amount of diversity and at their institutions and have not been sufficient. And second, neither California nor Michigan have the same levels of diversity today that they did before these constitutional bans, these state constitutional bans went into effect in their respective states.
Well, what do you, I mean, I asked that question and they had a pretty good response that the universities are unwilling to change other things such as legacy recruitment, legacy admissions and things of that sort. And it seems to me then the question becomes whether you have a compelling interest in sustaining legacy admissions. I think that was their point, that California has just refused to change other parts of their admissions process in order to allow socioeconomic status to do its work. So if that's true, that strikes me as the state bears the burden of showing narrow tailoring, and just because it hasn't worked, because the state hasn't changed other parts of this process, is not going to be enough to prove the burden, to meet your burden.
Well, if we look at the university, looking at modeling studies done by the University of North Carolina in 2007, 2009, and 2012, the admissions office reviewed race neutral alternatives and how they would impact the university's class composition, finding each time that there were no alternatives that could yield the same diversity and academic qualifications of students had all of those race conscious policies essentially been abolished. And UNC's policies do meet all 5 prongs required for their use of affirmative action to be narrowly tailored, which we go into more detail on pages 48 through 50 of our brief. UNC specifically has cited its interest in promoting student body diversity, which this court has, as my co-counsel mentioned, for half a century recognized as a compelling interest. Additionally,
the only diversity that is a compelling interest, diversity on the basis of race.
Sorry, we did not hear the first part of that question.
Is the only diversity that rises to the level of a compelling interest, diversity on the basis of race?
Well, we would look to Adirond, which held that all racial classifications imposed by whatever federal, state, or local government actor must be analyzed by reviewing a court under strict scrutiny, to say that in race, that is where we see that these have to be under strict scrutiny, because Adirond we see also explicitly reversed Metro Broadcasting, which was the only case of racial classifications that didn't use strict scrutiny and instead used intermediate scrutiny.
In your brief, you talk about one of the reasons that diversity is a compelling interest is because without it, you don't have the kind of dialogue, exchange of ideas, all these kinds of things. So is racial diversity and other are those things equivalent? In other words,
I think
get that kind of exchange of ideas and enhanced classroom dialogue with other kinds of diversity or only racial?
So we do believe that all kinds of diversity do yield this sort of unique and enriching dialogue. However, we just don't believe, we are not, at least not to our knowledge, have cases been brought before this court that challenge other sorts of diversity, such as on the basis of sex or gender or sexual identities, sexual orientation, in terms of college admissions and in terms of having a diverse student body.
And when we're talking about it, potentially the distinction between Title VII and Title VI, those have those two things have their different histories. And so when we're talking about Title VI that the petitioner brings up, which is the civil rights and discrimination case, where we're held to that as well, we know that in the case of race, that certainly is strict scrutiny. And so
what do you make of, just real quick, switching to stare decisis, what do you make of Justice O'Connor's point in Grutter that perhaps race-conscious admissions policies wouldn't be necessary in 25 years? We're now coming up on that expiration date. So does that suggest kind of it has less force as a matter of stare decisis? And your time's about to run out. You can keep going to answer the question.
Well, Your Honor, Justice O'Connor wrote that the court, quote, expects that 25 years from 2003, the use of racial preferences will no longer be necessary to further the interest of diversity. We would read that quote to be aspirational and not binding the court into reversing it exactly 25 years later. And as we explain on page 36 of our brief, although we're not arguing for the continuation of Grutter's holding, it won't last forever because Grutter was self-limiting. We discuss on page 37 of our brief that many schools already, such as Georgia, have adopted race-neutral alternatives without a drop-off in diversity, but schools like the University of North Carolina and as we've demonstrated, Michigan and California have not, which is why this decision ultimately should be left up to the states. And we urge a decision in favor of the respondents.
Okay, thank you. Counsel for petitioner, you have your rebuttal time. You can begin when you're ready.
Thank you, Your Honor. Your Honor, respondents' arguments fail for three primary reasons. First, respondents' arguments incorrectly hinge on their belief that the history of the amendment and of Reconstruction provide a basis for race-conscious affirmative action in their brief. Second, they assert that diversity is an extension of remediation, which directly contradicts this court's holdings in Wygant v. Jackson Board of Education. And third, in their arguments today, respondents claim that no feasible alternatives exist. They reference a 0.5% difference in minority enrollment, yet this court's holding in Gratz states that the fact that the implementation of a program might present administrative challenges does not render constitutional an otherwise problematic system. We yield the remainder of our time to the questions of this court.
Well, what do you make of your friends on the other side hit the California example hard, suggested that even though California has a state constitutional amendment that bars the use of race in college admissions, that the colleges themselves have suggested that this has proven unsuccessful. Why shouldn't we rely at least on their expertise, as Grutter suggested, in informing on whether there are whether this is narrowly tailored and whether there are alternative processes?
Your Honor, this court has long deferred to the expertise of universities when it cited, for example, the Harvard plan back and again in Grutter. And we've seen that it has only enabled discrimination to continue. Studies show that there are other ways to achieve the same diversity. The simple fact of the matter is that University of California, for example, refuses to implement certain policies that would increase diversity because they feel that the administrative challenges aligned with it would be too much of a burden. Petitioner's position is that we insist that there are other options for these universities to achieve it, and that they're not looking in the right spots, or they refuse to look in the right spots to achieve them.
And to add on to my counselor's point, we have deferred, this court has deferred to colleges for far too long, and it is time that this court returns to the meaning of the Equal Protection Clause of the 14th Amendment and rule the system of pluses unconstitutional.
Great. Well, do any of my esteemed colleagues have any additional questions?
I do not.
I do not.
Okay, well, if you want to sum up in the next 30 seconds, and we'll take the case under advisement.
To return to point one, respondent's brief argues that this interest has evolved from mediation, as it was during Reconstruction, in order to justify comparing diversity and remediation interests. Doing so is a dangerous analogy that misinterprets Reconstruction-era legislation to incorrectly justify modern race-conscious practices, which have the so-called interest of diversity for educational benefits, which petitioners establish is not a compelling interest by any means. Rather, looking further to Reconstruction would no longer represent the same race-conscious interest.
We thank the court for its time.
Thank you. The case will be submitted.
All right, everyone, thank you so much. The other team can move from camera. Let me be the first to congratulate you. What you just did was not easy. This is a very hard case, and you prepared arguments at the level of any moot court championship I've ever been to. More impressively, I've seen you all grow through 4 rounds of this competition. You get better and better each time. You make stronger arguments. You avoid pitfalls. I've noticed things that you didn't do in the past that you did here, which is better. And also you were responding effectively to your friend on the other side, which means you're paying attention. You were responding to what the judges said as well. It was very conversational. This was a very effective round, and I'm very, very always pleased to see you guys' performance. So it makes me very happy. I don't know. Things are often very cynical in our society. I think people are very jaded, but this is one of my highlights of my year. So thank you so much. I welcome the judges to get some feedback as well.
Sure. Yeah. So I thought you both sides did a fantastic job. Obviously, a very contentious case, but you knew the law back and forth. You were able to cite case law that just goes past Brown to kind of the nuts and bolts of current doctrine. I thought that was very impressive. That means you put a lot of time into it. I was very impressed by both of the briefs. This is a very difficult area of the law, and you kind of went into the facts in the North Carolina brief, and then also some of the big picture stuff. I thought you responded to the arguments well. So for instance, when I rely on the text, maybe the text doesn't support you, so you point to the original understanding and the Freedmen bureaus, and then vice versa. When I highlighted the Freedmen Bureau, kind of it seemed like it was preferential. You were able to say that maybe, well, that was race neutral, in fact, actually. So both sides kind of responded to the arguments. You would not believe how many times, I call it filibustering. Counsel just will talk without saying anything, and then they don't respond to the question. I usually give counsel a few times. I'll follow up and say, I'm not certain that you answered my question, and I'll just give up and I'll hold that against them in my head that they didn't really have a response. So I thought you both handled some of the toughest parts of your case quite effectively. And I thought the tone was great. I thought as I said at the past council, my biggest problem when I was an advocate was just talking too fast. I thought you both talked at a reasonable conversational tone. So that was fantastic as well. So congrats, you both did a great job.
I would second that. You all 4 have a lot of composure. You surely don't seem to be just high school kids.
Yes.
You don't. I'm just very impressed by your ability to look into the camera, and it's hard to make eye contact with somebody who's on a screen. All 4 of you did that very well. And you were all well aware of both the strengths and the weaknesses of your positions. And I think that you responded to the questions very well. I agree with Judge Murphy. Over the many, many years that I've been doing this kind of thing, I've judged a lot of moot courts, and you 4 could have held your own with law students. You did very well.
Great. Yeah, I also want to echo what's been said. guys did an excellent job, both in terms of the brief and the presentation here for argument. And as Josh said, you guys give us hope for the future. This is a very divisive issue, but you guys cited cases and arguments, and then sometimes now we look in newspaper on Twitter and see our leaders, behaving the way they do, and with certain arguments, you guys, provided your arguments with reason and with case citations, and it was excellent.
That's awesome. And let me just put out one additional point. I think what makes this case so hard is it's real for you all, right? You are all high school, what are you, juniors and seniors, I think memory serves? You're all high school juniors and seniors. You are applying right now, or you're admitted perhaps to various colleges. And so this decision affects you, it affects your siblings, it affects your friends. And you're sort of sitting here in this kind of period of like uncertainty, where you're arguing at this case in the abstract, knowing full well this will affect who you are, what school you get into, who's gonna be on your campus. And I thought both teams took themselves out of the equation and were able to argue objectively, zealously on behalf of an imaginary client, right? So you're not really lawyers, right? But you're able to advocate zealously on behalf of an imaginary client, such that I don't know from these arguments what you actually think about this case, nor should I know, right? If you're a good lawyer, it shouldn't matter what you think. You walk into court and you give your client your best day. And I think all four of you did that perfectly. But you also did it respectfully. You disagree with the other side and you sort of push back, but it was very gentle. It wasn't fierce. It wasn't like, my client on the other side's an idiot, right? You'll see that stuff. You'll trust me, in the Sixth Circuit, at least I saw it. Sometimes lawyers said things they should not have said about their opposing counsel. I clerked there many, many years ago. I was like, what'd you just say? I've got almost about, we'll mention the Ninth Circuit. We don't know what goes on in there. You were respectful. And that's very good. Always be courteous to your friend on the other side. So the petitioner said this, and that's a good tone. Your cadence was good. Your pacing was good. Judge Murphy made a fair point on speed. That all of you had good pacing. You were not rushing. And also, I think you use your time well. Sometimes when there's about 30 seconds left and nothing left to say, you can say, Your Honor, if there are no further questions, I see the balance of my time. You can do that. Right, there's nothing wrong with that. It's often said.
And sometimes the panel of the court will love you for it.
Yeah. It's often said that sometimes you can talk too much. You can actually dig yourself a hole. So if things are looking pretty good and you made all your points, counsel, Your Honor, if there are no further questions, we're happy to cede the balance of our time. Sit down. I remember at one case when I was clerking, everything was going right. The lawyer sat down after about a minute, like, Your Honor, if there are no further questions, that was it. And he won the case. Sat down, and that was it, because the other side made a fool of himself. So there was really nothing for the respondent to do, and he said, "Okay, for the appellee, I'm going to sit down now." All right. Are there any questions from the students, either from me or for the judges? It's a very unique opportunity with three very distinguished judges here. Happy to hear your questions for them.
I have a question regarding clerkships. I definitely do want to. I'm not asking
Looking
for
well
right
into
now.
the future.
Oh my God, these kids! Okay, I didn't even know what a clerkship was when I was in high school. God bless you all. All right, go ahead.
I just wanted to know what your thoughts are on like the value of a clerkship and whether or not that a federal judge clerkship would be a valuable experience for someone coming out of a law school.
Well, you're asking the wrong people. I mean, we're the judges who need to get good clerks. So naturally, we're going to say it's very valuable, but trying to be objective about it, yes, it is. It'll give you the opportunity on either, whether you're clerking on the district court level or on the appellate level, it gives you an opportunity to see how the system really works from the inside.
Yeah, I would. I clerked twice. So I'll say a couple points. All three of us mentioned the last time the importance of legal writing, and so it'll be a year that's largely dedicated to writing. That you're going to do this no matter what, and if you're a trial lawyer, you're going to have motions that you have to write briefs or motions in limine. Writing is just a part of being a lawyer, and so practicing it is the way to improve. That's certainly the way I found. And in retrospect, frankly, I don't think I was prepared as much as I should have been. I focused largely on when you get to law school, there's these terrifying end of the year, end of the semester exams, which are 3 hours long. You just type really fast and you just find all the issues, and the style of the writing doesn't matter as much. So I didn't just kind of the what you're learning now, high school grammar, rules of grammar, as Judge Batchelder said, topic sentences, transition words. This stuff wasn't important. And then I get to legal writing. I think I had more of a learning curve than I should have. Thankfully, I clerked for a wonderful writer. I clerked for Judge Wilkinson, who was a newspaper reporter beforehand. So they obviously have to know how to write very well. So I learned a lot that year in terms of writing, as Judge Batchelder said, in terms of just learning how judges think. I come out and talk to my clerks all the time. Just kind of, I do a lot of my thinking orally. And so I need somebody to talk to, so I don't talk to myself. And the clerks are the people we can talk to for these purposes. So yeah, I think I would say you should, I mean, it's still a long way to go. I think you need to worry about doing well in college and then in law school, but it's good to have that in on the back of your mind already about setting goals for yourself.
Kind of in a similar vein to that, this is Quinn and I are both seniors, and this is my last year doing this competition, which I've really had so much fun with. Do you guys know of any opportunities or just any advice that you would give for undergrads of what we could do after this to kind of continue the same things in a different sense?
Judge Lee, do you want to start?
I know a lot of colleges have mock trials, which is obviously a little bit different. So it probably depends on which college you go to. They'll have similar things like this, I think, that you can participate in. Another important thing, I think, just to echo what Judge Murphy was saying, just writing is very important. And a lot of times students who come into law school or become lawyers, they really haven't written that much and they struggle with it. So, to the extent you can get a lot of writing experience in college, taking writing courses, writing for the school newspaper, I think that'll help you in the future.
Yeah, I mean, there are moot court competitions. So again, mock trial is generally, as the name suggests, a trial with a jury and a judge. You have rules of evidence. It's very procedural based, right? Where there's lots of people involved. Whereas what they call moot court is kind of what we do here, which is where we take basically an appellate decision and we have arguments with two or one advocate at a time. Most colleges should have undergraduate moot court programs. I encourage you to try out for that. They're very good. There's also college debate, which is a related skill, but it's not exactly the same. Debate's a bit more polemical. It's a lot more argumentative, where you're trying to score points against the other side. It gets a little bit, a terrible example, Ted Cruz, who was our senator and who was our Solicitor General. He was a national debate champion, and you could see it in his style, right? It's a little bit more combative, whereas I think moot court is much more, less bombast, right? Less passion, even tone. When you're in a mock trial competition and you're speaking to a jury, you have to use emotion, right? You have to sort of bring a lot of these sorts of things. So to Katie's question, seek out all the above, right? You might find you like one over the other. There are lots of good trial lawyers who cannot find their place in appellate court. And there are lots of good appellate lawyers who cannot find their place in a trial court. I don't know what I would do in a trial court. I'd be very lost. I don't even know what objection. I don't know, right? It'd be very weird for me. But see what you like. You're all very talented, and you're all 17, 18 years old, however old you are. I'll say this with respect. You do not know what you want to do yet. I mean that sincerely, right? I don't mean that any pejorative, but you have such limitless potential that you don't know what you're going to gravitate to. I went to school for computer science. That's why I studied undergrad. I want to do computers. And then I went to law school because I want to do IP. Look at me now. I never took a single IP class in my life, right? So you never know how your path will sort of unfold. Judge Batchelder mentioned a few months ago, she was an English teacher, right? You don't know where life will take you. And that's why going to college, having an open mind, doing as many of the various tournaments and competitions and groups as you can really cements you. There are what they call pre-law majors. I'm somewhat skeptical of them. I don't really know many law students who did that. I don't know, Eric, just lady, just bachelor. I don't really know people who've done that. But at least take undergrad classes in civil rights or in constitutional law or anything else. Those are
Yeah,
good.
I would add, it's like you have to be an all-around good lawyer, which is good writing, so that would be English. You know, you need to know some aspects about American government, American history. So I was in history and economics major, and I thought both of them added different things. So history was kind of the knowledge of the law, like, you know, this case, for instance, there's a lot of history in it, right? So you need to know basic aspects about history. But there's a lot of like thinking like a lawyer, which is learning to pick holes in arguments on the other side and identifying them. I don't know that my history major, that was just more memorization in order to do well. My economics major, however, I needed to kind of like apply theorems. There would be questions where I would know the concepts, like, or with math too, like you know how it works and then you have to apply it. That's going to be the law school exam. You'll learn the material, and then in law, they're going to ask you hypos that are not in the material, and you have to kind of deduce how the legal principles you've learned apply to these new facts. And I actually found, I think, that my economics major was more valuable than maybe even pre-law, because that's kind of what we were doing. We learned the basics of, like, you know, supply and demand, price goes up, and then there would be this hypo in the exam, and I'd have to say, well, what are going to be the economic consequences of these actions? And it was in that respect similar. So it just depends. I mean, I think you learn different skill sets in different areas, all of which can add value to a law degree.
This is kind of a broad question, so sorry if it's hard to answer, but I was wondering, what's the hardest part of being a judge? Like, what's the hardest part of your jobs?
Question. Good question.
Judge Batchelder, you can start.
Well, I've been doing it the longest time. I suppose it makes sense that you turn to me first. I think the hardest part for me is when I'm confronted with a situation where it's clear to me what the law is, and it's clear to me how it has to apply to these facts, and I hate it. I do not want to have to come out that door, but that doesn't matter. That can be a difficult situation to be in. But I do it.
Yeah, I have when I was a practice, you'll find the difference quickly between being a practicing lawyer and being a judge. So being a practicing lawyer, you have a fiduciary duty to your client. That's a fancy term that means you owe like a significant duty to protect your client's interests even more than your own. So you have to advocate for them whether you agree or not. So I didn't really think much in many of the cases about whether it was right or wrong. I was just like, well, I know the outcome I am shooting for, and I'm going to do my best job trying to write the kind of the most persuasive brief. And I don't need to really worry about what is right. The transition, I've actually struggled quite a bit. There's a lot of easy cases for sure. But I find that there are a lot of hard cases that I read one brief and then I read the other brief, and this is where I come talk to my clerks. I'm like, I have no idea. Try to help me out here, and then we have debates. But I would be interested, Judge Lee. We were appointed at close to the same time. If you had the same reaction, or if I'm just out to lunch, I actually still have. I found it difficult going from an advocate to a judge, a decision maker.
No, actually, that's the exact same feeling that I had. Was, the easy part of being an advocate was, you're ethically bound to present, any plausible argument, reasonable argument on behalf of your client. You didn't have to worry, whether it was, the quote unquote correct answer. That was your duty. Being on the other side, you actually have to figure that out, and that is actually a lot of times difficult. And also another thing that makes it difficult is just a wide variety of cases we have to handle here. When I was in private practice, I specialized in certain areas of law. I knew that very well. So in many ways was, I kind of had a lay of the land. Here we get so many different cases. You got to learn whether it's the law or even the facts. Just a case we heard last week, it's about denture products and trying to learn how these denture products operate, and it looks painful. I mean, the screws, it's, oh my gosh, but you have to learn the factual background to understand some of the legal issues. So that's part of the fun aspect of the job. But it makes it, I think, very difficult. And I guess I'll mention one other thing that I don't like is trying to compete to get law clerks every year. I don't like that process. And Alex, I think you're in luck. I think Judge Murphy is hiring for year 2030 through 31. Right? So you may want to put in your application right now.
Well, don't laugh. I know there are judges, your colleagues who hired college seniors who are going to admit to law school. I'm not joking. People, Robbie George's graduates, they're getting hired as seniors before they even step foot in law school. I'm serious. So you have people who are basically being hired for clerkships 5 years out before they even step foot in a law school classroom. Based on
Let me just say to you four, don't be discouraged by that. There are so many tremendously well-qualified kids out there. And if you continue on the path you're on, you won't have any trouble at all.
I'm sorry, I shouldn't even mention that, but I used to joke that Judge Kavanaugh would hire clerks in vitro, right? Just as soon as,
I wasn't that bad, but I used to say we were going to be getting them out of kindergarten before too much longer.
Yeah, I mean, when I went to law school back in the Stone Age, and I think Judges Murphy and Lee had some experience, there was a calendar, right? There was a hiring schedule where the judges were not even allowed to talk to the clerks until the fall of their 3L year. Remember that? That was the calendar. And of course, half the judges ignored the calendar because they're just, and there's antitrust, you can't force them to. But at least for most judges, you were hired your third year in law school in the fall, and you could apply over the summer, and the interviews were this 1 week in September where you could have interviews. And I had a bunch of interviews back to back to back, but now it's a free for all. So to Alex's question, the clerkship process is just completely decayed. But I hear Judge Lee and Judge Murphy and Judge Batchelder, there are so many smart law clerks who are hired on the regular cycle in a normal pace, and the three of you are just too spectacular. I'll see you guys in some court in a couple of years. I don't know where, but I'll see you around. And I'll wait. Remember me? I was that guy with the Zoom, and then you'll see me. Okay. What other questions you have for us?
I just have one question for the judges, and you could each answer it if you want to. What case is currently on the Supreme Court docket that you're most personally interested or excited in seeing the outcome of?
What do you think?
Interesting.
So let me speak up and say, I'm not going there.
Yeah.
Yeah, I don't know that I'm going to have a good answer. Most interested in. I'm trying to think if I have any of my own cases up there, but I would definitely be most interested. I don't think I've got a couple, there are cert petitions pending, but I don't think I've had any. I was very excited. There was this esoteric statutory interpretation case where I dissented in the Sixth Circuit last year, and my views got vindicated. So that was, I put a lot of time into the case. DeVita, it was
the dialysis case, right?
Yeah.
Okay, good.
So yeah, I spent a lot of time on that, so that was nice. You put a lot of work in these cases, so but yeah, I can't think of one now.
Judge, anything up for the Ninth Circuit? Oh, there always is. But anything in particular that you have an interest in?
I did have one, but it was dismissed. It was one of my cases on attorney-client privilege. The Supreme Court about 2 weeks after our argument, dismissed it. So I was happy that happened. So the general rule is if the Supreme Court accepts cert, there's about 2/3 chance they'll reverse. So I was glad that it was dismissed as improvidently granted, which means the court thought, all right, we really, we shouldn't hear this case at this point right now. So.
Oh, very cool. Not that anyone asked me, but the case I care about most is actually not a very attractive case, most personal jurisdiction. Norfolk Southern case. It involves whether a tort happened in Virginia, but suit was filed in Pennsylvania, and none of the parties have any actual connections to Pennsylvania except for the fact that the railroad drives through Pennsylvania, and whether that's enough for personal jurisdiction. This is very nerdy, but if you actually represent a company this could open up liability nationwide. And for my friends in Ohio, there's a huge Norfolk Southern accident that just happened there recently. I won't say anything else because I have some Ohio judges on the line, but this kind of decision could open up liability, not just Ohio, but any forum nationwide, where Norfolk Southern operates. So perhaps the courts in Ohio are better than the courts in some other states. People might choose other forums or forum, as our team there. Sorry, that was bad. That was terrible.
It's okay. I've heard it.
Never in this context. Okay. What other questions you guys have? All right. All right. So I'll just give you a preview. The judges and I will deliberate now for a few moments. We'll select the winner. It'll be one petition, one respondent. The championship round will be April 24th in DC. If things go to plan, we'll have Supreme Court oral argument in the morning. We get to attend an actual argument. I think I got the tickets. Don't quote me on it, but I think I got the tickets. We should be good. And the afternoon, we'll have the final round at the Georgetown Supreme Court Institute in Washington, DC. The panel, I think, will be Judge Katz from the DC Circuit, Judge Tom Griffith, who until recently was on the DC Circuit, and Judge McFadden, who's on the DC District Court. So a very good panel to hear the case, and we'll have some fun in DC. So I will say nothing more except thank you all, and I'm also proud of you. Keep in touch. Let me know when you guys clerk in the Supreme Court, and I'll follow you along over the years. Thank you so much. All right, bye-bye, students.
Thank you.
Thank you.
I'll turn off the recording now.